In the islands, British practice slavery is particularly brutal. There is, at one point, an actual overabundance of slaves, and the cost of slaves begins to drop from 35 to 25 pounds. In other words, from $5,600 to about $4,000. Plantation owners begin to find it more economical to simply let their slaves work themselves to death and replace them with a new cheap slave rather than maintain them. This results in slave rebellions, and the English in places like Barbados and Jamaica and the Carolinas will introduce these draconian slave codes. Slave codes set out minimum standards of captivity to prevent slave rebellions. A planter is required to provide annually every male a pair of pants and a cap, and every female a petticoat and a cap. Nothing is said about shoes, shirts, diet, working or housing conditions. Most infractions were often punished by death. A slave, for example, who steals a pig, the punishment is quartering. Quartering, in other words, they amputate his legs and arms. Defiant slaves are hung in trees, chained alive to starve by death. Slave resistance is punished by hanging a slave alive by a hook through their ribs, as you can see in this illustration. The British slave laws prohibit slaves from, quote, they're not to, quote, beat drums, blow horns, or use other loud instruments in the fear that they might be secretly communicating with each other. Inconspicuous cases of slave disobedience, British courts sentence all slaves to death, and they compensate their owners for the loss of a slave sentenced to death by a court. In fact, the mere suspicion of plotting to revolt results in slaves being burnt alive at the stake. There were slaves, for example, in New York that were burned at the stake still in the early colonial period. Life for slaves is brutal in the Caribbean, particularly in the Barbados. This is kind of a poem that a kind of disgruntled planter now composes. Barbados Isle inhabited by slaves, and for one honest man 10,000 knaves. Religion to these a romantic story, barbarity, and all got in ill-got wealth thy glory. All Sodom's sins are centered in thy heart. Death is thy look, and death in every part. O glorious isle, in villainy excel. Sin to the height, thy fate is in hell. Barbados. Certainly not the image of Barbados that we have today as a kind of a tourist destination. It was literally a hell. In one of those wars between France, Spain, and Britain, Britain prevails, and in the Treaty of Utrecht, 1713, the British now, through war, receive the right, or asiento, they capture essentially the asiento to trade slaves in the Spanish Indies. And so the British government now will auction off this new trading license, and a whole bunch of British companies now enter into an auction to bid for the asiento. The winning bid is won by a company called the South Seas Company. The British government will sell to the South Seas Company the Spanish asiento for the winning bid of £7.5 million, an extraordinary amount for that time. Its value today is approximately 1.2 billion US dollars today. That's how much the South Seas Company thought that the Spanish trade was worth. In fact, the South Seas Company is the Tory response to the Whigs, the foundation of the Bank of England to finance government debt. Just to give you some sense of, again, scale and money, what's 7.5 million pounds might mean. The entire British government debt after those wars with Spain was approximately 50 million pounds. 18.3 million pounds were held by three large corporations, 3.4 million by the Bank of England, 3.2 million by the British East India Company, and 11.7 million by the South Seas Company, which is the slave trading company. And now the slave trade starts to really boom, because not only are there slave trading ships, but they are now escorted by British soldiers and the Royal Navy. So-called slave factories are built, again, where you see those flags on that map are all British slave factories. These, again, slave factories, as they're called, are protected by British military personnel, by the Royal Navy. Captives now, captured inland by African kings, are transported to these slave factories where they will be auctioned off, processed, packaged. One of the biggest and most notorious of these slave factories is going to be Bence Island. And here you can see a glimpse of what Bence Island looked like and looks like. It's now a museum. Bence Island was run by Scottish traders. It was an offshore fortified island. The way it worked was that ships would arrive with trading goods. They would then, the cargo would be unloaded by slaves, while the crew could have rest and recreation. There were three known existing golf courses in the 18th century. The Bence Island Golf Course was one of them. In fact, there was a brothel and a golf course with African slaves dressed in Scottish kilts acting as caddies for ship's crew that wanted to play a round of golf. These facilities could easily pack approximately 400 slaves into a now super slave ship. These ships are kind of reminiscent of super oil tankers. They were especially built for the transport of ships and could, as I say now, mass ship slaves into the New World under horrendous conditions. But again, keep in mind that a slave that is transported in conditions in which he or she will die is not exactly good for business. You can't sell a dead slave. So again, the 15% fatality among slaves is the same fatality that ship's crew had. Whatever was killing crews was killing the slaves. The slaves, as I say, had to be brought to market in good condition. And so here, the slave trade into the 13 colonies now, which will become the United States, begins to grow with the rise of tobacco exports from Virginia, rice from the Carolinas, and in fact, Bent's Island is operated in particular and financed jointly between London partners and rice plantation owners in South Carolina. And by now, slaves, of course, as the Dutch and the French are being expelled from these regions, the British are now essentially settling the entire Atlantic coast of what is going to become both the United States and Canada. It is at this moment as well that as the colonies are being settled by the American Revolution, there'll be about 250, a quarter million slaves prior to 1776 in the 13 colonies. But there begins to be a kind of resistance, particularly from northern colonies, to the slave trade. One of the problems, of course, is indentureship. Indentureship is actually a form of white slavery that was practiced, except this was temporary. A person in England can indenture themselves for a sum of money for a period of time where their transport to America will be paid for by the person who bought their indentureship, and they have to work off as an indentured slave 5 years for the person that indentured them. And once that indentureship period expires, they are then freed. Usually, an indentured slave, white slave, could be bought for 22 pounds and an axe and a barrel of corn. And there is a trade in indentured slaves. Not all proprietors could make their enterprise work, and so if they have an indentured slave that's still they can't use them anymore, they're desperate for money, but they have this indentured slave, and there's maybe 2 years, as in the case in this advertisement left, they can sell their indentured slave, they can sell the indenture to somebody else. Servant girls here, you can see, are being sold. 100 healthy servants, men, women, and boys, tradesmen, blacksmiths, shoemakers, tailors, glaziers, even a jeweler. So there are some historians that argue that what we might refer to as, white trash, southern white trash, are actually descendants of indentured white slaves, that the poor white trash experience kind of has a parallel experience to African American poverty as a result of slavery, that there is a kind of a mutual slave tradition or background, sorry, I wouldn't call it a tradition, but a mutual slave background among those living in poverty in the United States, white or black, although, of course, the children of indentured servants were not automatically enslaved or indentured, and again, a state of indentureship was not permanent. It was contractual. But it's a problem. The problem is, of course, in England. In England, it's a problem because there are periods, particularly after wars in England, that there are depressions, and suddenly there's massive unemployment in England, and the British would prefer that some of the employed left Britain and moved into the colonies, moved across the Atlantic. And the problem is, and many of them are doing this as indentured slaves, but the problem is that for £22, you get an indentured slave for 5 years, plus you have to give them an axe and a barrel of corn when you free them. So you get for £22, you get an indentured slave, but for £25, you get a black slave forever. And so there is this preference for just purchasing a slave outright. This also becomes a problem in terms of skilled labor settling in the New World. Skilled laborers, as I say, tinsmiths, shoemakers, blacksmiths, carpenters, if they have to compete with slaves, who are also, as you saw from those lists, often taught these trades, why would they bother ever immigrating from Britain to the New World if they can't practice their trade unless they're, enslaved? And so there began to be, in certain northern states, laws were introduced that slaves cannot be educated in skilled labor, in various guild trades and so forth, as bricklayers and so forth, and as well, local colonies began to impose tariffs to discourage slavery as well. So the first abolitionist movement in North America, in the North, is going to be economically related and economically blessed. There's very little about essentially the morality of slavery or ethics and so forth. There are some religious groups that begin to focus on slavery. The Religious Society of Friends, as Quakers call themselves, they begin to slowly take a position, a negative position on slavery, although there were early Quaker slave traders, but certainly among German Quakers in Pennsylvania and Massachusetts, there is an early American abolitionist movement among them, based essentially on the morality or immorality of slavery. So here we can see the kind of arrival, the core arrival of African slaves into what will become the United States. We're not far from the 360,000 or so that will make up the original import, and after that, as we'll see, once Britain abolishes slavery and begins to enforce the abolition of the international slave trade, most of the 4 million American slaves that exist at the moment that the Civil War breaks out were actually natural-born African Americans, descendants, some of several generations of slaves who had originally been brought back from Africa. And you hear, of course, the history of slavery in the United States now begins to split. 1776, of course, we have the American Revolution, and partly the American Revolution was a tax revolt, essentially. And one of the things that first things that the revolutionaries did is they immediately not only threw tea, British tea imported into the U.S., on which Americans were expected to pay a tariff, but they also prohibited the landing of slaves, which was much more valuable than the tea market. And so there was this outcry among British slave owners to the King of England that the American colonialists are essentially endangering a very lucrative and important slave trade for the British economy, and that he better send the military out to put this down. That is part of the genesis of the American Revolution. But regardless, by 1776, we're now going to have a split. And so I'll take you to the two different journeys that slavery is going to take, and see why, it's going to be problematic to abolish slavery in the United States, but less problematic in Britain. There is in Europe, with the Enlightenment, with the 18th century writings of Enlightenment philosophers like Voltaire, Diderot, Jean-Jacques Rousseau, Montesquieu, Marivaux, all of them condemn and denounce or mock the institution of slavery. And in England, you begin to see this moral opposition to slavery begin to emerge in the pages of the British popular press. They begin to portray slavery as something cruel and almost un-English. For example, the English Weekly Miscellany in 1738, as early as that, asks the English how would they feel if African traders began to seize British subjects from the coastal towns of England. Gentleman's Magazine publishes a letter in 1740 declaring that men were born with a natural right to liberty and that they could only forfeit that by stealing the property of another. That the loss of liberty of a parent is no reason that a child should be enslaved. And by the 1770s, the Quakers themselves begin to pronounce a stand now against slavery, not only for members of their own religion, but as well they take a stand against slavery as an evil in general and begin forming these anti-slavery societies. And so we begin to see slavery and the abolition of the slave trade, this kind of unique and new British sentiment in the public press and in public popular opinion. Crucial as well to the abolition of slavery is English legal thought. The nature of common law and the judicial systems of the English-speaking world, including the United States and Canada, is still today often determined by the principles of Sir William Blackstone and Blackstone's commentaries on the laws of England, which were published between 1765 and 1769. They are still the foundations of how we interpret criminal, civil, and constitutional law to a great extent. It's studied in law school. Before Blackwell wrote his books, and Blackwell essentially, there was no criminal code in England the way we know, the criminal code of Canada, for example. There was no criminal code like that. laws were kind of interpreted by decisions made in courts by precedent. Often one decision conflicted with another decision, and so Blackstone, in his commentaries on the laws of England, um, kind of resolved some of these conflicts, and out of Blackstone's commentaries, eventually the British will codify a single criminal code as it's codified in Canada. In the United States, every individual state has its own criminal code, and then there's a schedule of federal offenses as well. But before Blackwell's book, before the 1760s, the major guideline in the Western world remained Emperor Justinian's Institutes from the year 533. In fact, they too are still a required reading in law school. A lot of Justinian principles, and maybe we get the term justice from Justinian. A lot of Justinian principles are still important today. For example, you can't try somebody twice if they're accused once of a crime and acquitted. They can't be retried for the same crime. Nothing that is specified at the time that the act is committed can be considered a crime retroactively. You can't do something and then somebody passes a law making that act illegal until that law is passed, and even after that law is passed, if that particular act was committed before the law was passed, you cannot retroactively charge people with it, and so forth. Those are Justinian principles. And Blackstone, in his commentaries, argued that in the practice of British common law, there is no slavery. He says, essentially, correctly, that there are only 3 states of slavery recognized in the Justinian Code: 1 by virtue of conquest, 2 by selling oneself into slavery, or 3 by birth. You're born to a slave and therefore born in slavery. Blackstone writes that the common law of England, quote, abhors and will not endure the state of slavery within this nation. And so he, at first, he insisted that, quote, a slave or a Negro, the moment he lands in England, falls under the protection of the law, and with regards to all natural rights, becomes eo instante, instantly, a free man. Now, once the slave issues start being debated in England, Blackstone is going to attempt to backpedal somewhat on that pronouncement. In the 2nd edition of his book, as people begin to petition for the abolition of slavery in Britain, Blackstone will begin to qualify his statement. He will now, in the 2nd edition, claim that a master's right to his service may probably still continue, but in the 4th edition in 1770, he then backpedals again, and the word probably is itself amended to possibly. So Blackstone's under a lot of pressure, but nonetheless, the problem that is beginning to become visible in England is that as plantation owners are retiring, some of them are liquidating their plantations or selling their plantations, they return back to England and they bring their slaves with them. And so you begin to see thousands of slaves in England. And this, of course, now sets the stage for this precedent-setting court case in 1771 in England that is going to be kind of the first blow against slavery in the British Empire, in the British experience. Grenville Sharp, He's a typically eccentric upper-class Englishman. He's the brother of William Sharp, who was the personal surgeon to King George III. The Sharps, 8 brothers and sisters, were the children of a prominent Anglican church official. Their grandfather was the Archduke of York. The Sharps are privileged. They are well connected, and they are social activists and active and prominent social activists, and slavery is certainly an issue. Now, 17, there you can see Grenville Sharp in the close-up, sitting there near the center. One day, 1765, a 17-year-old black youth by the name of Jonathan Strong, who had been brought back to England from Barbados by his owner, David Lisle, a lawyer, is so severely beaten that Lisle believes that he had killed him. He actually almost knocked his eye out of his socket. And so David Lisle beats Jonathan Strong into unconsciousness, and when he thinks he killed him, he just leaves him for dead on the street corner in the streets of London, the way you'd leave a dead horse in those times. Jonathan Strong, however, is not dead. And he's staggering about. His eyes are swollen shut. There's blood pouring from his head. And somebody on the street now directs Jonathan to a street clinic that is run by William Sharp, Grenville's brother, the king's surgeon. Again, as I said, they're social activists, and William Sharp every morning holds this clinic open for the poor of London who can get medical help that otherwise they could not be afforded. This is the king's personal surgeon. Grenville at that moment is visiting his brother, William, at the clinic, when Jonathan Strong now staggers through the clinic door. Grenville himself will later recall, he says, quote, "The boy seemed ready to die and almost lost the use of his legs and feet, and to complete his misfortune was afflicted with so violent a disorder in his eyes that there appeared to be the utmost danger of his becoming totally blind." End of quote. And so the surgeon, William Sharp, now tend to the injured Jonathan, and they arrange for him to be admitted to St. Bartholomew's Hospital, where essentially it took him 4.5 months to recover under treatment by William Sharp. When Strong is released from hospital, the Sharp brothers now find him work as an apprentice with a pharmacist around the corner from William's medical office. 2 years now go by when David Lisle, the former owner, or still owner, of Jonathan Strong, is walking in the street, and he's astonished to see his slave working in the pharmacy. And so and quite healthy and alive. And so Lisle now, quite sneakily, sells Jonathan Strong to a Jamaican planter. Jonathan Strong has no idea that he has been seen by Lisle, and that Lisle has now sold him to this Jamaican planter who is planning to go back to Jamaica, and he's going to bring Strong with him. And so the Jamaican planter now and the ship's captain hire two men to kidnap Jonathan Strong, throw him in jail, and have him held in jail until the next ship sailing for the West Indies is ready to sail. Now, you have to understand, in those days, police did not exist. If you were a victim of crime until about the 1830s, if you were a victim of crime, it was you, or if you were murdered, your family's responsibility to identify, capture, and prosecute in a court a suspect. And the way it worked is you would go before a magistrate, you would present your evidence. If the magistrate felt the evidence was sufficiently compelling, the magistrate would then issue an arrest warrant. You then, with that arrest warrant, would hire a sheriff or a thief taker as their own and pay them to arrest that person. That person would then be escorted to a jail, and you would pay the jailer to hold and feed that prisoner until the case comes to court. And then you would have to argue in court before a judge and jury your case. And if the case is proven to the satisfaction of a jury, they issue a verdict, and only at that point does the state take over. And there were no penitentiaries at that time. Mostly the punishment was either exile or death. And there were hundreds of anything from stealing a loaf of bread to a piece of laundry was covered by the death penalty, because essentially there was no penitentiary system. But you were essentially the investigator and prosecutor, and you had to use the services of a sheriff and jailer. So it's very easy to argue up some case before a magistrate. If you have money, get that arrest warrant, hire a sheriff to seize your person in the arrest warrant, and then pay a jailer to hold them, which is exactly what happens to Jonathan Strong. Eventually, of course, the British government began to give people small sums of money so they could hire a lawyer to prosecute a case before a judge and jury. And eventually the state said, we'll actually begin employing permanent prosecutors to do that, rather than giving money to people to hire a lawyer, and thus you get the kind of adversary prosecutorial system that we today all are familiar with. But that's how it worked. That's, of course, why you have the Habeas Corpus Act. Habeas corpus, essentially translated directly, means to produce the body or to have the body. Often people think that habeas corpus means, you have to have the body to convict someone for murder. You actually don't. But what habeas corpus means is an order from a judge for whoever is responsible for a person to be being held in prison, to produce that person, produce their body before a judge, and justify and give probable cause as to why their imprisonment should be continued. And if there is no probable cause, then of course under the Habeas Corpus Act, that person is released. This is a fundamental right that the Anglo-Saxon tradition in law continues to have its former British colonies like Australia, Canada, the United States have the principle of habeas corpus. European continental countries do not. Try telling someone in France about the Habeas Corpus Act, and they look at you like you're from planet Mars. In Europe, if you're charged, you're guilty until proven innocent. Habeas corpus, of course, underlying that fundamental principle is that you're innocent until proven guilty, and anybody who interferes with your liberty has to sufficiently prove to a judge that there is just cause for holding you. That's how remand works in Canada today. If you're arrested for any reason, the police, within 2 days of your arrest, if it's a weekend or the next business day in court, if it's not a weekend, have to bring you before a judge for an arraignment. The either prosecutor or the police officer who maybe arrested you on the summary arrest, in other words, there wasn't an indictment, has to explain what the probable cause is, the issue of whether you will be held on bail and allowed, or you will be released on bail to come back another day to stand trial, or not, is often settled in the arraignment as well, and so that is where habeas corpus is tested. And of course, habeas corpus can be suspended, and has been often suspended, both the United States and Canada. We're going to see Abraham Lincoln suspend habeas corpus when the time comes. But habeas corpus can be selectively suspended for certain crimes, as for example, in the Patriot Act in the United States, the Anti-Terrorism Act in Canada suspends habeas corpus for those who are charged with an act of terrorism, or plotting a terrorist act, or aiding and abetting terrorists. You don't get the same rights as someone who's charged with murder or bank robbery. You don't get to question the witnesses who had provided information leading to an arrest. Your lawyer may not have access to you. You don't have the right to bail or arraignment. It depends on each country, can suspend habeas corpus in very different ways. In Canada, we used to call them the Suspension of the Habeas Corpus Act. Certainly we called it that in the 19th century. We, as I say, suspended habeas corpus during the Fenian crises in Canada. We had numerous Irish insurgent threats that led to us suspending habeas corpus. It was suspended during the FLQ crisis under the terms of what's called the War Measures Act, and of course, in the United States, it's suspended under what was the Patriot Act. So all these anti-terrorist legislations, in fact, are essentially a suspension of habeas corpus act. But it's a very old Anglo-Saxon principle, as I say, going back to 1679. We can call it the law of liberty, if you want to look at it that way. So Grenville, of course, now files a petition of habeas corpus. And Grenville, of course, as I say, has connections, and so he's listened to. And here you can see, actually, Grenville charging the ship's captain with kidnapping Jonathan Strong. He physically, when you're charged or arrested, you know, why do police insist on putting their hands on you? It's not only a matter of that they don't want you to run away, but there is there has to be a kind of physical contact to complete the charge and arrest part of it. Theoretically, if a police officer is attempting to arrest you, but he hasn't managed to actually touch you, and you run around the circle around the cop car, you're still not under arrest. Although you're now committing another crime, you're committing the crime of fleeing an arrest and so forth. But there has to be a kind of physical touch to implement a charge and arrest. And that's what Jonathan Strong is doing here in this illustration. And so Grenville Sharp is now going to argue, as he gets standing in the court, that under the provisions of the Habeas Corpus Act, a master had the right in a slave only if he could prove that the captive in question had in writing willingly bound himself without compulsion or illegal duress. And so when the captain is brought before the judge, the Lord Mayor at that point of London, the question is now put to the captain. Well, since we don't recognize the institution of slavery in British law, what crime has Jonathan Strong committed under which you have taken him as a prisoner and holding him in jail? And of course the response was, he's a slave, he's the master's property. And of course the judge shrugs his shoulder and says, well, that's not an offense, and we haven't recognized formally the institution of slavery in Britain. Yeah, there are slaves here, but there's no real standing for slavery in the court system. And now a Lord Mayor judge now orders Jonathan Strong to be immediately released, since his habeas corpus rights have been violated. And it's a first victory for the cause of abolition of slavery. Of course, it doesn't abolish slavery, nowhere near it. And of course, at the core of the argument was that Lyle had abandoned his property, that he just left Jonathan Strong in the street. And now, as the result of the Jonathan Strong case, Sharp becomes this advocate as black slaves in England, threatened with sale back to the colonies, begin to petition Grenville Sharp as their advocate and savior. And so he begins to argue in court on a number of cases, and begins to win freedom for slaves in cases where their owners might have freed or abandoned their slaves, before changing their minds. But he can't get a ruling that slavery in itself is actually illegal. It's not legal and it's not illegal, and it's kind of a Netherlands. And now in 1772. The case is going to be tested. A new case comes up, the case of James Somerset. He's brought by Charles Stewart to England from Virginia. James Somerset, a slave, escapes and then is recaptured and put on board a ship bound for Jamaica. And unlike the other slaves who had been abandoned, this is not a clear-cut case in that way. And so Grenville Sharp now takes on the Somerset case. It becomes known as the James Somerset versus Charles Stewart case. It's going to be argued. There you have your notations of it. It's going to be argued in the Court of the King's Bench under a very prominent judge, Lord Chief Justice Mansfield. Mansfield is a personal friend of Blackstone. Mansfield himself owns a slave, a mulatto girl, a biracial girl who he takes into his household as a member of his own family, and upon his death, he's going to free her and endow her with a sizable fortune, but he is a slave owner. Lawyers for Somerset are going to argue that Africans, once on the territory of England, had the same rights as anyone else. Once they set foot on England ground, they were, quote, subject to the same laws that their masters were. Thank God. There is, in fact, an Elizabethan case where a Russian merchant who owned an English slave brought that English slave with him on a visit to England, and the English slave immediately escaped, and the British courts found that while slavery may be recognized outside of England, once a slave takes a breath of English air, they are automatically, instantly freed. And so that's one of the precedents again for this kind of abolitionist path that is going to be taken in Britain. Lawyers, by the way, for the owner, argue that there were thousands of black slaves in England brought by their owners, and that they were worth collectively about £800,000 at that time, which would be about $120 million today, and that if they suddenly were all set free, there would be an economic crisis in Britain. The trial lasts nearly 4 months, and Judge Mansfield is desperately trying to get an out-of-court settlement to avoid making a ruling. He doesn't want to make a ruling, but this case is a focus of newspaper articles, public debate, and slavery. Mansfield begs British Parliament and the House of Lords to please pass some kind of law, either abolishing slavery or endorsing slavery. Make it legal or make it illegal, but don't leave it in this gray area. The Parliament refuses to introduce any legislation resolving this question. And so Mansfield now makes what is known as the Mansfield Decision of 1772, that again, some people interpret that this is abolishing slavery, but it doesn't. Mansfield holds that slavery was so odious that nothing could be gained to support it, even if positive law about the issue did not exist. And so Mansfield's decision was that a master has no right to compel a slave to go into a foreign country for any reason. That in the case so odious as the condition of slaves must be taken strictly, the power claimed by this return was never in use here. No master ever was allowed here, in other words, in England, to take a slave by force to be sold abroad because he had deserted from his service or for any other reason whatever. And so, essentially, it doesn't abolish slavery, but now, once a slave owner brings a slave to Britain, that slave can never be sold against his own will. As and the slave, by the way, is released. Benjamin Franklin, in fact, sneers when he hears about the Mansfield decision. He says, England is congratulating itself, quote, on its virtue, love of liberty, and the equity of its court in setting free a single Negro, end of quote. And this is precisely around the time that the 13 colonies are beginning to, launch their tax rebellion against Great Britain. So here he is, William Murray, the first Earl of Mansfield, Lord Chief Justice of King's Bench, a very controversial judge. And here's his statement on slavery. He says, "The air of England is too pure for a slave to breathe, and so everyone who breathes it becomes free. Everyone who comes to this island is entitled to the protection of English law, whatever oppression he may have suffered and whatever may be the color of his skin." 1770s. That, by the way, William Murray, Judge Mansfield, is where the often quoted term "possession is 9/10 of the law." In other words, once you possess something, once you have it in hand, it's essentially 9/10 of the law. The case in England that will finally galvanize English slave abolition is the sinking of the Liverpool slave ship, the Zong. You're looking at the Turner painting, the Zong. September 1781, the British slave ship Zong is sailing between Jamaica and Saint Dominique with a cargo of 442 African slaves when it gets lost at sea. Drinkable water becomes scarce. Slaves are beginning to get sick and they're dying. The captain, he calls together the crew and explains to them that if slaves die aboard the ship, naturally, the loss would be to the ship's owners. And of course, the crew would lose their bonuses. The way crews would get paid often is they get a share in whatever the shipment earns at the end of its destination. The captain tells them that their bonuses are at risk if these slaves continue dying aboard the ship. If, however, the slaves are thrown overboard while they're still alive to protect the crew from a communicable disease or to provide them with sufficient rations of water or to save the remaining crew, the ship's insurance company would have to pay for the loss of slaves under the maritime insurance principle concept of sacrifice under the pearl of the sea. That essentially says that the insurance company is liable to cover any losses if the captain decides that by jettisoning its cargo, he can save the ship from sinking or save the lives of the crew and so forth. The insurance company, under the concept of as a sacrifice under pearl of the sea, will have to pay the coverage. And this, of course, immediately gives you a hint of just how many other different companies, including insurance companies, are involved in profiting from the slave trade. And so the crew now proceeds to throw 133 live captive slaves into the water alive over a period of 3 days, essentially putting them to death. When the ship arrives, back in port, the ship's owner, James Gregson, now files an insurance claim with the insurance company, Gilbert Insurance, demanding payment of £30 per slave. Gilbert Insurance Company now refuses to pay this claim, disagreeing with the captain's decision. I mean, typical of an insurance company, right? You pay insurance premiums until you make a claim, and then, of course, they deny the claim. James Gregson sues the insurance company in King's Bench, and a jury upholds the ship owner's, James Gregson's, claim. The insurance company now appeals, and the appeal is heard by the Lord Chief Justice Mansfield. Once again, he's on the scene. The case will become known as Gregson versus Gilbert, 1783. Grenville Sharp and other abolitionists, when they hear about this case, they become enraged, and they now make an appearance in the court, trying to get standing in that court. They petition Mansfield that this is ridiculous. This is not a question of an insurance claim on cargo. We're talking about murder. The ship's captain and the crew and the ship's owner should be charged with murder, according to Grenville Sharp. And Mansfield dismisses them. He throws them out of the court. He says, quote, "The matter left to the jury was whether it was from necessity that the slaves were thrown into the sea, for they had no doubt, though it shocked one very much, that the case of slaves was the same as if horses had been thrown overboard." And so when Mansfield says this, that essentially this is a case of just cargo like horses being thrown overboard, it really begins to outrage public sentiment. Now, the kicker here, of course, is that Mansfield rules against the ship's captain anyway, despite the fact that he still diminishes slavery and any questions around slavery as a property question, as opposed to a question of personal liberties in this case. Mansfield finds, and the jury finds, that the captain had actually miscalculated the amount of water available for the crew and slaves, and therefore had made an error. It was a captain's error that the slaves were thrown into the water needlessly, and is therefore not an insurable peril of the sea. And so the insurance company wins the case. Indeed, the insurance company wins the case. Zahn case, however, horrifies legislators in Britain. It terrifies an 8-year-old boy who hears this story in his father's barber shop as the trial was taking place. That boy's name is William Turner, and 63 years later, in 1840, he would paint this masterpiece of a painting that you're looking at, Slave Ship. It hangs today in the Boston Museum of Fine Arts. But this case, Gregson versus Gilbert, the Zahn case, really begins to set the tone for the final years of debate in England. We, of course, currently are talking about Dundas Street and Lord Dundas, who was one of the pro-slave members of Parliament arguing for slavery, while many parliamentarians were arguing against slavery. It finally there will be a Abolition of the Slave Trade Act introduced in 1807. It passes the British House of Lords by 41 votes to 20. The House of Commons, it's carried by 114 to 15. And the abolition of the slave trade becomes law on the 25th of March, 1807. It does not abolish slavery. It abolishes the trade in slaves. British captains who are caught trading in slaves are fined £100 for every slave found aboard. Not a very smart decision, because of course as soon as a slave captain sees British naval ships on the horizon, he'll start throwing slaves into the water not to be caught, with a slave on board at £100 fine for every slave. The British Navy now, of course, that used to protect slave routes, will pursue slave traders. We eventually are going to see quite some time later. I mean, we're talking some 20 years later. We're going to see that Parliament will finally abolish slavery. Not just the slave trade and British participation in the slave trade, but just slavery anywhere in the British Empire will be abolished in 1833. This, of course, brings us here to Ontario and to Toronto in particular. When I lecture at Ryerson, I often like to point out that Ryerson is on the same ground where slaves used to work, plantations that belonged to the Jarvis family. One of the largest slave owners in Toronto was William Jarvis. The reason slaves were here in Ontario is of course they come after the American Revolution, as a lot of Ontario is settled by Americans who remain loyal to the Crown, and they left the United States, revolutionary United States, as refugees, and they brought with them their slaves here. And to encourage this kind of settlement of what is going to be known as the United Empire Loyalists, the most loyal of Canadians, essentially, but many of them, as I say, were slave holders, and to encourage their settling in Canada, they were allowed by Lord Simcoe, who was the Lieutenant Governor of Ontario, to bring their slaves with them. So in 1793, already Simcoe had banned the slave trade in Ontario, but he did not abolish slavery completely, because, quote, so far as the same may gradually be done without violating private property. He wanted to gradually abolish slavery. No new slaves could be introduced into Upper Canada as Ontario becomes known after 1793. Those who were slaves here before will remain so. The children of those female slaves born in Ontario would be slaves as well until the age of 25. And then once they reach the age of 25, under Simcoe's regulations, they were supposed to be freed. But there was a slave presence here. We see in the Old Toronto court records, William Jarvis reporting the escape of two of his slaves, asking the Toronto police to find him, a Negro boy, quote, a Negro boy named Henry, commonly called Prince, and a girl, end of quote. She's not named. So technically speaking, a black female slave born in Toronto in 1792, let's say biologically she could produce a child as late as 1825. He or she would have remained a slave until 1850, had Britain not in 1833 passed the Slavery Abolition Act, and therefore this whole gradual abolition of slavery becomes instant in 1833, and all slaves after 1833 will be freed in what is today's Ontario. So that gives you some scope of the British experience with the slave trade. The American experience is going to be diametrically different. And so in the next lecture, I'll go back to what happens in the early period of the United States and the path that slavery will take that, and that will kind of be the chronology that we're going to now follow all the way to the outbreak of the American Civil War and beyond that.